The box is small. The consequences are not. By 5:15 a.m., the first detainee of the shift is processed under the new protocol. A 34-year-old man arrested the night before on a misdemeanor DUI in Anaheim. Under the old system, his fingerprints would have run through state and federal databases, and if ICE wanted him, ICE would have had to come get him within a narrow window. Under the new system, signed into force at 12:01 a.m. on June 30th, 2026, a deputy trained and deputized under Section 287G of the Immigration and Nationality Act now conducts the immigration interview himself, inside the jail, wearing a Sheriff's Department uniform with a federal delegation card clipped to his belt. The interview takes 12 minutes. By 5:41 a.m., a federal detainer is lodged. The man will not be released. This is what the deal does. On paper, it is a memorandum of agreement between U.S. Immigration and Customs Enforcement and the Orange County Sheriff's Department. 72 pages, signed by Sheriff Don Barnes and ICE Enforcement and Removal Operations Field Office Director Moises Becerra. On the ground, it is more concrete. The quiet transfer of a federal function into the hands of roughly 40 local deputies who completed a 4-week training program at the Federal Law Enforcement Training Center in Charleston, South Carolina. Those 40 deputies now hold what the statute calls Designated Immigration Officer Authority, interrogation, database access, the power to issue detainers, the power to begin removal proceedings from a jail intake desk. Orange County is not the first to sign. It is the largest in California to sign in 2026. The framework itself is old. Section 287G was written into the Immigration and Nationality Act in 1996, buried inside the Illegal Immigration Reform and Immigrant Responsibility Act. For a decade, it sat mostly unused. After 2006, it spread across Arizona, Georgia, North Carolina. After 2014, it contracted. After 2017, it expanded again. By July of 2026, ICE lists 287 active agreements across 40 states. Orange County's is the newest. There are 3 versions of the program, and the difference matters. The jail enforcement model lets deputies identify and process removable individuals already in custody. The warrant service officer model is narrower. Deputies serve ICE administrative warrants on inmates, but conduct no interviews. The task force model, the most expansive, deputizes officers to enforce immigration law in the field on patrol during traffic stops. Orange County signed on to the first and third. The jail enforcement piece activated June 30th. The task force component activates October 1st. That is the piece changing the streets. Sheriff Barnes, a 32-year veteran of the department, framed the agreement at a June 24th press conference in Santa Ana as closing a loophole. He stood at a podium with the ICE seal projected behind him. He spoke for 11 minutes. He used the phrase public safety 19 times. He did not use the word deportation once. Across town, at a community center on Bristol Street, a different press conference was happening at nearly the same hour. Attorney Samir Ahmed of the ACLU of Southern California called the deal the most significant expansion of immigration enforcement in Orange County in 15 years. He predicted lawsuits. He predicted a chilling effect. He predicted, specifically, that domestic violence reporting in immigrant neighborhoods would drop within 90 days. He was drawing on data. In 2013, when the county last operated a full 287G program, reports of domestic violence in Latino households in Santa Ana fell 12% in the 6 months after activation. Reports of sexual assault fell 22%. Those numbers came from a University of California Irvine study published in 2019, and they are the numbers now appearing in every op-ed,
every city council meeting, every union hall. Not fewer crimes, fewer calls. Inside the sheriff's department, the operational reality is more specific than either press conference suggested.
The Intake and Release Center in Santa Ana processes roughly 175 bookings per day. Under the new protocol, every foreign-born detainee, determined by place of birth data pulled from the booking questionnaire, is routed to a secondary screening station on the second floor. That station is staffed 24 hours a day by two 287G certified deputies working overlapping shifts. Their supervisor reports to a lieutenant. That lieutenant reports, in a dotted line arrangement written into Section 4.2 of the MOA, to the ICE field office in Los Angeles. That dotted line is the whole story. A county employee, paid by county taxpayers, taking operational direction from a federal agency. The MOA calls this coordinated supervision. Critics call it something shorter. The money moves in one direction. ICE reimburses Orange County for training costs, about $8,400 per deputy, but the county absorbs the salaries, the overtime, the facility upgrades, and any resulting litigation. Internal projections presented to the Board of Supervisors on May 18th put the annual net cost to the county at $3.7 million in year one, climbing to $5.2 million by year three. The vote to approve the agreement passed 3-2. Supervisor Katrina Foley voted no. Supervisor Doug Chafee voted no. The 3 yes votes came from the board's Republican majority. Foley, speaking after the vote, said one sentence that made every local news broadcast. "We are paying millions of dollars to become a federal contractor without any of the protections of a federal contract." The contract itself contains one unusual clause. Section 9.7 gives ICE the unilateral right to terminate the agreement with 30 days' notice. The county has no equivalent exit. To withdraw, the sheriff must formally petition ICE and wait for a response that the MOA does not obligate ICE to provide within any specific time frame. That is not a partnership. That is a lease. The first legal challenge arrived on July 1st, less than 24 hours after activation. The Orange County Immigrant Youth United Coalition, joined by the Mexican-American Legal Defense and Educational Fund, filed suit in the Central District of California. The complaint runs 84 pages. It argues the agreement violates the Fourth Amendment by authorizing prolonged detention on the basis of civil immigration status, and that it violates the California Values Act, SB 54, which restricts most local law enforcement cooperation with federal immigration authorities. That last argument is the one keeping county attorneys awake. SB 54, signed in 2017, was designed precisely to prevent this kind of arrangement. It carves out narrow exceptions. Cooperation is permitted for individuals with certain serious felony convictions, but not for misdemeanor arrestees, not for traffic offenders, not for individuals held on charges alone. The MOA does not, on its face, acknowledge these limits. Section 3.4 authorizes screening of all foreign-born individuals booked into county custody. All. Not some. Not those convicted of qualifying offenses. All. The county's legal position is that SB 54 is preempted by federal immigration law when a valid 287G agreement is in place. That argument has never been tested in the Ninth Circuit. It is about to be. While the lawyers file briefs, the deputies file paperwork. In the first 72 hours of the program, according to figures released by the Sheriff's Department on July 3rd, 47 individuals were flagged for federal detainers. Of those, 31 were booked on misdemeanors, 9 were booked on felony charges, 7 were booked on failure to appear warrants for prior traffic infractions. 7.
for traffic warrants. Consider one of them. His name is Jorge Delgadillo. He is 41 years old. He has lived in Orange County for 23 years. He works as a landscaper for a company in Costa Mesa that maintains office parks along the 405 freeway. On the evening of June 29th, he was stopped on Harbor Boulevard for a broken taillight. The stop revealed an unpaid traffic citation from 2022. He was booked into the Intake and Release Center at 8:47 p.m. At 11:14 p.m. on June 30th, under the new protocol, active for less than 24 hours, a 287G deputy interviewed him. By midnight, he had a federal detainer. His wife, a U.S. citizen, was told he would not be released. She learned this over the phone. She had 3 children in the room. The youngest is 6.
She asked her mother, in Spanish, when her father was coming home. Her mother did not answer because there is no answer to give. That is not a hypothetical. That is one file in a pile that will grow every day. The obvious question is why the sheriff would sign this deal in 2026, when the last version of it ended in 2017 under community pressure and cost overruns. The answer runs through 2 channels. The first is federal. ICE has been aggressively expanding the 287G program under the current administration, offering expedited training slots and priority processing for participating jurisdictions. The second is local. The Board of Supervisors majority campaigned in 2024 on immigration enforcement, and this agreement was sitting on the shelf waiting for the right moment. The right moment was a 32% year-over-year increase in property crime reported in unincorporated county areas. The sheriff cited that figure at the press conference. He did not cite the follow-up number, published by the county's own Office of Independent Review, showing the increase correlated with staffing shortages in patrol divisions, not with the immigration status of arrestees. That distinction did not make the podium. Inside the jail, the mechanics continue. The new booking form is a single laminated sheet. Question 14 asks, place of birth. Question 15 asks, how long the individual has lived at their current address. Question 16 asks about family members in the household. None of these questions existed on the booking form 6 months ago. All 3 are now standard. A deputy who spoke to reporters on condition of anonymity, a 12-year veteran of the department assigned to the intake floor, described the change in one sentence. We used to book people. Now we interview them. That is the operational shift. Not a raid, not a convoy, a checkbox, and a laminated card. The task force component, activating October 1st, will extend the same authority into the field. Deputies on patrol will carry federal delegation credentials. During traffic stops, they will be authorized to ask about immigration status, run individuals through federal databases, and make arrests based on civil immigration violations without waiting for ICE to arrive. This is the piece that most closely resembles the Arizona model of the late 2000s, a model that produced the Melendrez versus Arpaio litigation, federal monitors, and a decade of consent decrees. Orange County has studied that history. County Council has budgeted an additional $1.4 million for anticipated civil rights litigation over the next 24 months. That line item is on page 47 of the fiscal impact statement. It exists because the county already knows what is coming. The system worked exactly as designed. That's the problem. The community response has been organized and specific. On July 2nd, a coalition of 34 immigrant rights organizations announced a hotline, 714-ICE-INFO, staffed by trained volunteers in Spanish, Vietnamese, Arabic, and Korean. Orange County is home to the largest Vietnamese population outside of Vietnam. It is home to one of the largest Arabic-speaking communities in Southern California.
The hotline handled 1,247 calls in its first 36 hours. Most of the calls were the same question, phrased different ways.
If I call the police, will they call ICE?
Under the new protocol, the answer is not simple. Patrol deputies are instructed, per department policy, not to ask about immigration status during victim or witness interviews. But if an arrest occurs for any reason, including a warrant discovered mid-conversation, the booking process now triggers automatic 287G screening. So, a domestic violence victim whose partner is arrested will see that partner interviewed by a federal officer within hours, even if the underlying crime has nothing to do with immigration. Attorneys are advising clients accordingly. The advice, in most cases, is silence. The county did consider a narrower agreement, the warrant service officer model alone, for example, which would have limited local involvement to serving ICE warrants on individuals ICE had already identified. That option was presented to the Board of Supervisors in a March 2026 briefing. It was rejected as insufficient.
Supervisor Andrew Doe, one of the 3 yes votes, said during the May 18th debate that a limited program would send the wrong message about our commitment to federal partnership. The message being sent is now unambiguous. It is being received differently in different zip codes. In Santa Ana, where 78% of residents are Hispanic or Latino, the community response has been public and direct. A candlelight vigil on July 1st drew an estimated 2,400 people to the plaza outside the Ronald Reagan Federal Courthouse. Speakers included 2 pastors, a high school student who read a letter from her detained uncle, and a former sheriff's deputy who resigned in 2018 over the previous 287G program. In Newport Beach, 12 miles south, where 82% of residents are non-Hispanic white, there has been no organized response of any kind. The 405 freeway runs between them. The freeway is 14 lanes wide at its widest point. The distance across, in social terms, is measured in something else entirely. The first federal transfer under the new agreement happened at 6:12 a.m. on July 2nd. A white ICE prisoner transport van, a Ford Transit, plate reading GSA federal issue, pulled into the Sally Port at the Intake and Release Center, loaded 11 detainees, and drove them 47 miles north to the Adelanto ICE Processing Center in San Bernardino County. Adelanto is privately operated by Geo Group under a federal contract worth about $60 million a year. It has capacity for 1,940 detainees. As of July 1st, it was holding 1,847. The Orange County transfers pushed it to 1,858. 92 beds remained. At the current transfer rate, those beds fill in 8 days. Which brings the story to a question ICE has not yet answered publicly. Where do the transfers go when Adelanto is full? The likely answer is Mesa Verde 1CE Processing Center in Bakersfield, or Otay Mesa Detention Center in San Diego, or, increasingly, facilities in Arizona and Nevada. The logistical footprint of the Orange County deal extends across 4 states before it is 30 days old. Jorge Delgadillo, the landscaper stopped for a broken taillight, was on the July 2nd transfer to Adelanto. His attorney filed a motion for bond the same afternoon. The hearing is scheduled for July 21st. Between now and then, he sits in a facility he has never seen before, in a county he has never visited, waiting for a judge who will decide whether 23 years in Orange County outweigh a 2022 traffic ticket. His wife has not stopped calling the hotline. His children have not gone back to school this week. His employer, a small landscaping firm with 11 workers, has left his truck parked in the yard. The other crews drive past it in the morning without speaking. Return to the parking lot behind the Intake and Release Center. The Tahoes are still there,
The shift changes at 7 a.m. and 3 p.m. and 11 p.m., and the checkbox is still on the booking form and the laminated card is still clipped to the belt of the deputy on the second floor. The agreement will be reviewed at 12 months. It will be renewed automatically at 24 months, unless one party gives notice. There is only one party with the practical power to give notice. At 4:47 a.m. on a Tuesday in Santa Ana, the exact hour this story opened, the parking lot fills again. Different vehicles, different deputies, same checklist.
And somewhere in the county tonight, a phone is going to ring. And a woman is going to have to decide whether to answer it, and whether to say what happened, and whether the person who arrives in response will be the person who helps her, or the person who takes her husband away. That decision is now the deal. That decision, made 1,000 times a night across a county of 3.2 million people, is what the 72 pages actually mean. The box is small. The consequences are not.